Act applies to any person who acts as an agent of a foreigner. So we are rewarding it to mean it's the same thing. It says this act applies to an agent of a foreigner. So to remove any avoidance, to take away any doubt that any person may mean another third party, we are saying it relates to an agent of a foreigner. In clause 2.2, we are saying for avoidance of doubt, this act applies to an agent of a foreigner who engages in any of the following activities through any means, including the use of digital platforms. For example, engages in political activities in Uganda to further the interest of a foreigner. Solicits, collects, disburses or dispenses contributions, loans, money, or any other thing of value for purposes of financing or sponsoring political activities for further the interest of a foreigner. For example, if I'm Attorney General and I receive money from a foreigner to move a motion of any nature, that's prohibited activity. Represents the interest of a foreigner before an agency or official of government for purposes of engaging in political activities. Recruits, contracts, engages, enters into partnership or sponsors any person in Uganda to promote the interests of a foreigner for purposes of engaging in political activities. So those are the changes we are making there. In clause 4.4, we want to make some clarification. And we are saying, for avoidance of doubt and notwithstanding the provisions of this section, this act shall not apply to monies or funding received from a foreigner by a supervised institution or any other institution regulated by a regulatory body under an act of parliament for the purposes of meeting its regulatory requirements or for purposes of undertaking its commercial license or permitted activity under an act of parliament. For example, a bank, it is regulated, it is licensed to do lending. So if it receives money from a foreigner, it is not for those activities that are set out in 2.2. It is for lending. So, but we are saying for avoidance of doubt, because we've heard what their concerns are, so we are saying for avoidance of doubt, let's clarify what this means. By a health or medical facility for purposes of performing an activity permitted under the laws of Uganda to be undertaken by the health or medical facility. C, an academic or research institution for purposes of funding research and innovation or any other educational activity permitted under the laws of Uganda to be undertaken by an academic or research institution. D, a person for commercial, domestic, or family use. And E, faith-based organizations for activities that are connected with the mission of their faith-based organization. So we are saying that notwithstanding, nothing in this act shall be construed as prohibiting or requiring compliance with this act for lawful foreign direct investment, portfolio investment, diaspora remittances, export proceeds, trade finance, commercial loans, humanitarian assistance, technical assistance, grants, concessional financing, development assistance, or any other lawful foreign exchange inflow and such related activities. Page 8, Honorable Chair and members, we are proposing to refine the definition of agent of a foreigner. To read agent of a foreigner means a person who engages in activities referred to in section 2. What? I said page 8, Munana. So what we are looking to do here is to attach the activities to which this bill is attached, to which the application of this bill in section 2 to the agent of the foreigner, meaning that a person cannot be called an agent of a foreigner for purposes of this act if they are not conducting the activities that are set out in section 2. we are proposing to delete clause E at page 9, which was talking about disruptive activities, to include employing, recruiting, and engaging, sponsoring, or contracting any person to promote the interests of a foreigner. While it has got the issue of the interest of a foreigner, it was quite wide. So we are proposing that be removed, because the activities that are set out in clause 2 clearly set out what is prohibited. At page 10, we are looking to redefine foreigner to mean a person who, for purposes of this act, foreigner for purposes of this act, to mean a person who engages, undertakes, supervises, controls, or subsidizes the activities specified in clause 2.2, in section 2.2, and include, for the inclusion we are deleting a Ugandan citizen residing outside Uganda, and we're also deleting the discretion of the minister to designate someone as a foreigner. The important thing here is that for a person to be called a foreigner for purposes of this act, that person must do the things that are prohibited in clause 2.2. So if, for example, a person is a foreigner here but has not done any such thing, he is not a foreigner for purposes of this act. Foreign policy, to clarify on foreign policy, which was originally set out in clause 10, now we are putting a definition here to say means a policy developed by a foreigner and has not been adopted by the government of Uganda. So government policy is also defined here to mean a statement, decision, or actions of government on how a sector is regulated or governed, issued in accordance with the Constitution and the laws of Uganda. So interest of a foreigner means interests of a foreigner that are not aligned with the policies and laws developed by the government. Pardon?
And adopted by the government.
Developed and adopted by the government. Interest of Uganda is at page 11, means the national interests of Uganda based on the principles of national interest and common good enshrined in the national objectives and directive principles of state policy as provided for in the Constitution, the laws of Uganda, and government policy. We are proposing to delete the use of a person, the natural person, all through the bill. Where the bill had a person, we want to replace that with the agent of the foreigner, so that we are clear that the person we are talking about in respect to this law is only that one who is defined under the agent of the foreigner. Political activity, we are defining political activities to mean any activities aimed at influencing the enactment of law, formulation of policy, or decision-making of government, or for the people, or of the people of Uganda, and includes fundraising, sponsoring, fostering, nominating, supporting, or campaigning for a candidate in an election, registering, funding, and campaigning for a political party in an election, fundraising, campaigning, canvassing for support or opposing a political party or candidate in an election, any activities aimed at influencing the outcome of an election, any activities aimed at influencing the will and consent of the people of Uganda to determine who shall govern them and how they shall be governed, and any activities aimed at influencing, imposing, or normalizing ideologies which are inconsistent with the Constitution or which are inconsistent with the culture, customs, and norm of any communities listed in the third schedule of the Constitution. Honorable colleagues and members, just maybe to give, like, for example, by way of example, if, for example, a Ugandan did not agree that we should have the crude oil pipeline, a Ugandan, you and me, did not think that it was necessary because of maybe green environmental concerns, we did not want to have our oil extracted. You and I should be at liberty to promote that policy that we should not have oil extracted. But when I receive money from a foreigner to promote that agenda, that is where the problem starts. So a Ugandan is at liberty to challenge and question any policy. But once the person is doing that to promote, is sponsored to do that, that's where the problem is. So that's where we are here. So, in clause 2, this act only applies. We were saying the act applies to any person who acts as an agent of a foreigner. So we are rewording it to mean it's the same thing. It says this act applies to an agent of a foreigner. So to remove any avoidance, to take away any doubt that any person may mean another third party, we are saying it relates to an agent of a foreigner. In clause 2.2, we are saying for avoidance of doubt, this act applies to an agent of a foreigner who engages in any of the following activities through any means, including the use of digital platforms. For example, engages in political activities in Uganda to further the interest of a foreigner. Solicits, collects, disburses, or dispenses contributions, loans, money, or any other thing of value for purposes of financing or sponsoring political activities for further the interest of a foreigner. For example, if I'm Attorney General and I receive money from a foreigner to move a motion of any nature, that's prohibited activity. Represents the interest of a foreigner before an agency or an agency or official of government for purposes of engaging in political activities. Recruits, contracts, engages, enters into partnership or sponsors any person in Uganda to promote the interests of a foreigner for purposes of engaging in political activities. So those are the changes we are making there. In clause 4.4, we want to make some clarification. And we are saying, for avoidance of doubt and notwithstanding the provisions of this section, this act shall not apply to monies or funding received from a foreigner by a supervised institution or any other institution regulated by a regulatory body under an act of parliament for the purposes of meeting its regulatory requirements or for purposes of undertaking its commercial license or permitted activity under an act of parliament. For example, a bank, it is regulated, it is licensed to do lending. So if it receives money from a foreigner, it is not for those activities that are set out in 2.2. It is for lending. So, but we are saying for avoidance of doubt, because we've heard what their concerns are, so we are saying for avoidance of doubt, let's clarify what this means. By a health or medical facility for purposes of performing an activity permitted under the laws of Uganda to be undertaken by the health or medical facility. C, an academic or research institution for purposes of funding research and innovation or any other educational activity permitted under the laws of Uganda to be undertaken by an academic or research institution. D, a person for commercial, domestic, or family use. And E, faith-based organizations for activities that are connected with the mission of their faith-based organization. So we are saying that notwithstanding, nothing in this act shall be construed as prohibiting or requiring compliance with this act for lawful foreign direct investment, portfolio investment, diaspora remittances, export proceeds, trade finance, commercial loans, humanitarian assistance, technical assistance, grants, concessional financing, development assistance, or any other lawful foreign exchange inflow and such related activities. No, I think this just delete that. And such related activities. So we are saying, for avoidance of doubt, if there was anything unclear, we have tried to list out the things as much as possible that are not. But like I said when I was here the last time, the most important thing for members of parliament of this committee to look at is the application of the law. The law applies to only those activities which we have set out in the clause 2.2. At page 15,
we beg your pardon so that we can take
as what it should read. Nothing in this act shall be construed as prohibiting or requiring compliance with this act for lawful foreign direct investment, portfolio investment, diaspora remittances, export proceeds, trade finance, commercial loans, humanitarian assistance, technical assistance, grants, concessional financing, development assistance, or any other lawful foreign exchange inflow and related activities. Thank you. At page, we are making a correction at page 15H to add perform. It was reading, the department shall, any other function as the minister may assign to the department. So we are adding perform. Then at clause 5, at page 16, clause 5.4, we are amending it to read, it read originally a person who promotes. So we are amending it to read, an agent of a foreigner who intentionally promotes the interest of a foreigner against the interest of Uganda commits an offense and is liable. At subclause 2, at page 17, we are proposing to delete a person or for it to start with an agent of a foreigner shall not And at clause 3, relevant agency referred to in subsection 2 shall not approve an agent of a foreigner to exercise its mandate without cabinet approval. 4, we wanted to read, an agent of a foreigner who intentionally performs the functions or offers the services for which government is responsible without the approval of the relevant government agency commits an offense. Maybe I think this is some area where members had, some people who made submissions here raised the concern, and especially relating to grants and support. You could have a donor agency. For example, now Uganda today has an NDP4, and I'll use a school for example, and it says that we shall have one secondary school per constituency. So we are saying a foreigner should not come here and perform the function of setting up the school in any place without asking government. Why? For example, if 7 donors came and set up 7 secondary schools in one constituency, that's against government policy. It may not necessarily be harmful, but the government policy is let's have one school first in per sub-county, sorry. Yes, but what we are telling you is that if a person is donating to government, because you see, what we are telling you here, colleagues, these things have consequences. When the school is built, government must put the what? The teachers.
But
I think then you need it to be very clear.
Honorable member.
You see, we are talking about, because donations, we are talking about donations to government.
Okay, if there are donations to government,
and you see,
when you need to be clear.
Yes.
Then, because you see, you are talking of...
It cannot be the role of government to build private schools.
Yes.
So when we say an agent of a foreigner who intentionally performs the functions or services for which government is responsible, government is definitely not responsible for building private schools.
For providing
it's providing education.
And health.
Yes. And even if you're to build a private school, you need to do it with the consent of the relevant agency.
Honorable Chair, I thought we agreed we listened to the Attorney General in silence.
Yeah.
And we raised our questions.
Maybe, Chair, we can submit and then members can note and then ask.
And every member will be given an opportunity and ample time.
So at page 19, subclause 3, we are saying a person or agent of a foreigner shall not hinder, frustrate, or disrupt. So we are talking about, we are removing implement. Because an agent of a foreigner may be authorized to implement a government policy, but he shall not hinder, frustrate, or disrupt the implementation of government policy. There was nothing. Oh, sorry. Page 18, we go back to clause 7, development of government policy. At clause 3, we are saying an agent of a foreigner who wishes to influence or propose amendments to the development of policy shall submit his or her proposal to the relevant ministry, department, or agency of government for consideration. In 4, we are saying an agent of a foreigner who knowingly develops and implements a government policy in Uganda without the approval of cabinet. We are saying here that you come with a policy and say this is government policy, you commit an offense. 8, clause 8, we are looking to delete a government policy approved shall be implemented by the relevant government ministry, agency, or department. Because we are saying other people can implement government policy, not only those MDAs. And 3, we are saying an agent of a foreigner shall not hinder, frustrate, or disrupt the implementation of government policy. 4, we are saying an agent of a foreigner shall not carry out activities related to the implementation of government policy unless the agent of a foreigner has received approval from the relevant government ministry, department, or agency to carry out such activities. We are proposing to delete 5, which was reading a government ministry, department, or agency referred to in subsection 4 shall not issue an approval to carry out activities referred to the related to the implementation without the approval of cabinet. We thought that was a bit laborious. There will be a lot of red tape. You have to go back and forth. So we said the government agency should be able to do that. In 6, we are proposing for it to read where a government ministry, department, or agency issues an approval to an agent of a foreigner. We miss deleting or. To an agent of a foreigner to carry out activities specified in subsection 4, the government ministry department shall enter in an undertaking with the agent of a foreigner, providing for the manner in which the activities shall be performed. We are adding at clause 9, foreign policy of Uganda. We are adding of Uganda because you remember we defined foreign policy earlier to mean that policy which has not been adopted by the government of Uganda. So if you leave it here as foreign policy, it could mean it could contradict the interpretation given earlier. So we are saying prohibition of promotion of a foreign policy. It read earlier prohibition of promotion of a foreign policy of another country. But having defined foreign policy earlier, we are removing that. So we are saying an agent of a foreigner shall not engage in any activity, solicit, receive, or obtain any assistance from a foreigner to sponsor or organize a meeting or for any function with the aim of promoting foreign policy in Uganda that has not been adopted as a government policy. In 2, we are looking to remove a person, to remove any ambiguity, and say to start with an agent of a foreigner. At page 23, economic sabotage. We are saying we are proposing for it to read an agent of a foreigner who publishes false information or participates in any act or activity.
At page 21, you added intentionally to clause 3.
I've dealt with it.
Clause 3.
Yeah, clause 21. I beg your pardon. Clause 21, page 21, clause 11.3. We are saying that an agent of a foreigner who intentionally influences the will. So we're trying to introduce the mens rea to remove it from a strict liability offense. 13, we are proposing that should read an agent of a foreigner who publishes false information or participates in any act or activity that weakens, undermines, or damages the economic viability of the country, knowingly with the intention of causing economic disruption, insecurity, instability, commits an offense of economic sabotage and is liable on conviction to that. So here we are introducing intention, mens rea, and purpose. Again, this person does this purposefully, wanting to weaken the election, the economy. At page 26, this clause starts at page 25. We are saying where an application for registration is made to the minister under this act, the minister shall forward the application to the department to conduct inquiries into the suitability of an application and the applicant to the minister within 14 days from the date it is forwarded. So here we are introducing the timelines within which the minister should act. For the fit and proper test, in clause 2.2, we are saying that the person shall identify the character and mental health, not physical health, just the mental health. We are saying that in page 27, clause 17, the minister shall within 14 days upon receiving the memorandum, a recommendation. So here we are again giving the minister a timeline within which to make a decision in respect to the certificate of registration. And the refusal as well has been given the same time as set out in clause 2 below. So the minister must also respond in writing in case of refusal within 14 days of making that decision. At page 29, clause 21, declaration of sources. Subject to the provisions of the Anti-Money Laundering Act, an agent of the foreigner shall submit a declaration of the source of funds to the minister. So again, we had a lot of questions about this. I could receive money legitimately. I am being paid for services as a consultant, and I'm receiving, say, $500,000. Legitimately, it's good money. But the Anti-Money Laundering Act could require me to declare it under the Anti-Money Laundering Act, the Financial Intelligence Authority may flag it and ask that report. Because I have reported there, and I'm an agent of a foreigner here, it doesn't say I don't declare the source of the income to the minister, because the other one is dealing with money laundering. The moment I explain to them where I got the money from and it's not money laundering, the import and input of the Anti-Money Laundering Act ends. So this law is not saying that the money you're using here is illegitimate money, it's laundered money. No, it is legitimate money, but we are just saying, just declare it. In 3, saying we are removing an agent of a foreigner to replace it with, rather a person to replace that with an agent of a foreigner. In 22, we are deleting a person and making it, we are saying, this one there's a bit of an amendment, and I'd like to read it all and give the rationale. Restrictions on funding from foreigners. An agent of a foreigner shall not directly or indirectly obtain, solicit, or receive any financial support, donation, loan, or other assistance from a foreigner, whether in cash or in excess of $400,000 within a period, 400,000 currency, 20,000 currency points within a period of 12 years without declaring the funds to the minister. 12 months, yes, without declaring the funds to the minister. So what we are saying here is that the person can receive the money, doesn't need the approval of the minister, but must declare it. So the issue here, the issue we're dealing with here is that the members felt that the minister was being given a very wide discretion on how money can come in and how it can. So we are saying, no, you declare it, and if government finds it illicit, then they'll deal with it. But you've declared it. Now we are saying that an agent of a foreigner who obtains, solicits, or receives directly or indirectly funds, financial support, donations, loan, or other assistance from a foreigner without declaring the funds in accordance with subsection 1 commits an offense. So instead of requiring approval, it's requiring declaration. So we are saying that in 22.3, we are looking to delete again the person. As I told you, we are removing person and replacing it with an agent of a foreigner. In 24, we are looking to remove the discretion of the minister in 24.2, the discretion of the minister to allow people to get money. So all the money should be handled in accordance with the Public Finance Management Act. Then we move to clause 28, page 33, and we are saying, again here we are dealing with the issue of the wide discretion being given to the minister. A person appointed by a minister may, upon obtaining a court order at reasonable time, inspect premises. Because members are saying, no, the minister can send someone to my home at any time. So we're saying, okay, let's include an intermediary to deal with that discretion. So, honorable colleagues and members, that is the extent of our interventions. We have listened to colleagues, members. The minister would like to read draft 13 because he thinks it doesn't read well.
Can you go to 1323, page 23? I wanted to propose that we reframe it as follows: an agent of a foreigner who knowingly, so that, because there's a lot of repetition. 13, prohibition of economic sabotage. An agent of a foreigner who knowingly publishes false information to participate in any act or activity that weakens, undermines, or damages the economic system or viability of the country to cause, then we remove this knowingly with intention of, I think, to cause economic disruption, blah, blah, blah. I think knowingly should come earlier. It becomes simpler.
Just read it.
An agent of a foreigner who knowingly publishes false information or participates in any act or activity that weakens, undermines, or damages the economic system or viability of the country to cause economic disruption, insecurity, or instability commits an offense. So we delete knowingly with the intention of causing, and then we put knowingly up after who knowingly.
Honourable Minister, maybe just clarity. You have two